at 6:30 p.m. concerning the following petitions. Nextel Communications, 99 Willie Street. Are they here tonight?
Mr. Chairman, that's been continued again.
Okay, we have a note here for the August 14th meeting. This is going to be the last and final continuance. This has been going on for a good 2 or 3 months. I need does anybody here like to speak in favor for this petition and opposition, right? 99 Willie Street? Nobody here? Okay. We're going to need some type of motion for a continuance to August 14th.
Mr. Chairman, I think the correct date is August 21st.
It says August 14th here.
Okay.
Okay. August 21st?
Correct.
Okay. August 21st.
I'll make a motion to postpone.
I'll second the motion.
Call the roll, please.
Mr. Flynn?
Continue.
Mr. Belanger?
Continue.
Mr. Knox?
Continue.
Mr. Kazanjian?
Continued.
Mr. Squalia?
Continue.
Donna, please make a note that this will be the last, and if they don't show up on the August 14th, this is going to be the last time for them. Thank you. Robert Massey, 19 Edward Street, appeal and inspectional services of zoning officers, enforcement of the zoning ordinance, sections 4.3.5 for property at 1719 Edward Street. Mr. Massey?
Mr. Chairman and board members, this time I'd like to read a statement into the record.
Sure, go ahead.
Any objection to that?
Nope, go ahead.
Okay. To the City of Lowell, Mass. Board of Appeals, Alan Kazanjian, Chairman. I am Robert Massey, trustee of RSM Realty Trust and a resident of 17 Edward Street, Lowell, Mass. I originally had intended to represent myself and RSM Real Estate at tonight's meeting, but I have been advised by friends and associates to fight City Hall in this day and age without the proper legal counsel is at best suicidal. So I hereby request on this 24th day of July 2006 that this hearing on this matter be rescheduled for the 4th Monday of October so that I may obtain the best legal representation in the specialty of municipal code law enforcement. It is my intentions to vigorously rebut any and all allegations so set forth in the Inspectional Services complaint dated May 12, 2006. I fully intend to have my counsel show that the Inspectional Services Department of the City of Lowell, Mass. Have acted with malice and potential criminal violations of my civil rights. I intend to be fully compensated for all losses of my personal property and use of my home for the last 4 months, and forward to settlement of that matter to my satisfaction. I will also be seeking to receive punitive damage against any party who has participated in a scheme to violate my civil rights. Thank you, Robert Massey, RSM Realty Trust, as a trustee and individually. At this point, I would like to also have Ms. Bozak serve a copy of this to the chairman.
Thank you. Excuse me, Mr. Massey, this is, if I stand correct, you want to continue this to the August 14th meeting, is that correct?
To the 4th, I believe it said.
No, it's the 14th, I believe.
No, I don't think it was.
Oh, what do you say, October?
October, the 4th.
No, that's too far away. I mean, we'll give you
Well,
ample
that's
ti-
fine. I mean, that's your decision.
Okay.
Okay, I don't want to get involved in that.
Okay,
I'm not here to be interrogated. I'm here to make a statement, and that's it.
okay, we're not going to interrogate you, we're just going to give you enough time to get legal counsel.
The 4th, you meet on
August 14th.
Monday, right, of each month?
Yes.
Okay, it's to be continued. I'm asking for it to be continued. for the
Excuse me,
4th
sir,
of October.
can you step up to the podium, speak into the mic?
I'm asking it to be continued till the fourth Monday of October,
No, that's
1906.
that's too far away. We don't need to do that. To get legal counsel, we'll give you
That-
30 days
That's fine.
to
Whatever.
get legal counsel.
That's fine, then you
And
do
that
what
should
you
give you
have to
a-
do, and I will do what I have to do.
Okay, and I'll give you ample time to do what you have to do.
Simple as that.
Excuse me, Mrs. Murphy, can you step up to the podium, please?
You want? No, I'm leaving. I came here to make a statement, not to be interrogated. Come on, you want?
Mr. Massey was notified how long ago of this?
He appealed the decision and was put on the first available agenda, which was for tonight.
Okay, and he's the one to put the appeal on, is that correct?
He put the appeal in.
How long ago was that? Was that over 30 days ago? Okay.
June 16th, 06. 6/16/06.
Okay. Can you enlighten the board, just tell us what's happening with this property? This way you can make a decision, we can continue with this for 30 days or not.
As far as the city's concerned, this has been going on since at least 1988, with the health department, the building department, and the fire department sending numerous notices over the years, most of which are not signed for. There have been pictures and 2 court orders ordering Mr. Massey to clean up this property. And this last session has started, and he has given a handwritten appeal that he did clock in correctly with the clerk's office, and it's dated for this then, and we processed it for this first available hearing. But we have documents going back to 1988, all kinds of violation notices from building, health, and fire to clean up this property. And it doesn't appear to be much different today than it was then, except maybe more so.
Okay, thank you. Before I do open up this to the board, is there anybody here that'd like to speak in behalf of this petition? I know Mr. Massey stormed out of here, and we didn't have a chance to talk to him. Is there anybody else that would like to speak in behalf, either favor or in opposition? Okay, let's open up to the board, see what kind of questions they have while Mrs. Murphy and Mr. St. Hilaire are here. Go ahead, Jack.
Through you, Mr. Chairman, looking at the amount of violations that the city is stating that the petitioner is in a violation of, if these violations have been standing for as long, certainly as the city says they have been, I would concur that we need to address this as soon as possible. But I guess the other question I would have is, do we have the jurisdiction to overturn any of the inspectional services and that were addressed? And if we don't, then it's a moot point, and it needs to be settled by them and not by us.
We do have the jurisdiction to do that. The question is, we have to determine whether the building department did the right thing.
But there's also, the fire department is also involved as well, correct?
That's correct. But he's appealing the decision of the building department. So that's where we have to determine whether the building department did the right thing as far as acting on this, and we'll find out. Go ahead, Dan.
Thanks, Mr. Chairman. I guess my concern would be if the neighborhood is really, if this is a detriment to it, and the city's been in earnest trying to clean this up, I think she said since 1988 or something. I mean, I can understand and respect you for wanting to give them a month, but I wouldn't give them any more than that. I think that we need to do something. This gentleman's not obviously thinking about all the people that have to live there and deal with it also. So I think we need to support the building department and try to make their job so they can do it. And delays are just being costly to everybody that lives there. So.
Thanks. Thank you. Jack?
Through you, Mr. Chairman, I also agree with my colleagues that I feel that we should do something about this tonight. Thank you.
Well, I think Mr. Massey's stalling for time, so what we have to do, he's brought this thing up for legal counsel. We don't have a legal counsel here tonight. I think we can give him 30 days, and if he shows up, fine, we can discuss it then. If he doesn't show up, we can make our decision right then and there, but I don't think we're ready to make a decision tonight. I need a motion.
I make a motion to postpone for 1 month, the August 14th meeting, I believe it is.
A little later than that, probably a latter part of August. When is that, Donna?
Last Tuesday?
28th?
I'm sorry, the 28th.
28th of August.
Revise that to the 28th of August.
I need a second.
Second.
Call the roll, please.
Mr. Kazanjian?
Continue to the August 28th meeting.
Mr. Squalia?
Continue August 28th. Ms. McMahon?
Continue. Mr. Flynn?
Continue.
And Mr. Belanger?
Continue.
Mrs. Murphy, I want to thank you for coming and presenting the petition tonight for the building department. This can be continued for 30 days and see if Mr. Massey comes on legal counsel. Peter T., 278 Branch Street, to convert a laundromat to a restaurant without required parking in NB zoning district. Yes, sir.
Hi, yeah, my name Peter. So today I bring my friend to my property. Can you talk?
Can you please speak up so we can hear you? State your name and address, sir.
My name Peter, and my address 278 Brand Street.
Okay, your last name is
T.
Peter T. Okay.
Yeah.
Okay. Why don't you tell us what you'd like to do?
Excuse me. So today I bring my friend to my property. So my English is not very well. So
Okay. Why don't you bring him up to the podium?
Thank you, Mr. Chairman.
Can you state your name and address?
My name is Kubit Craig, living at 138 Tingsboro Road
Okay.
in North Chelmsford, Mass.
Okay. You're representing Mr. T?
No, I'm just trying to assist him in translation
Okay, great.
from Cambodian to English and
Okay,
vice
can you-
versa.
Great. Can you tell us what you'd like to do over there on 278 Branch Street?
មើលថានៅក្នុង278នឹងយើងចង់ធ្វើអីនៅកន្លែងនោះ
ធ្វើជា restaurant.
Yeah, I want to start a restaurant over there at 278 Brand Street.
Okay, does anybody like to speak in favor for this petition? In favor at 278 Branch Street? In favor? Anybody in opposition? Yes, ma'am. Ma'am, can you step up to the podium? Okay. State your name and address and,
My name is Hilda Zananeri, and I reside at 16 Dover Street. I live with my mom. She owns the property. Actually, we live about 3 houses up from the laundromat. You know, the street as is very congested. We have a park at the end of that road. All the kids park their cars. We have a rental apartment on 78, I think, Dover Street. Unfortunately, the apartment is not rented now, but when it's rented, our space in front of our house, it's never really ours. I always go out and speak to them. I say to them, we have 2-3 cars in this property, or we need our space. There's absolutely no way they could put a restaurant on Branch Street, because the street is residential, and we have no parking. It's a nightmare on that street. And I'm really opposing putting a restaurant at that corner.
okay, thank you very much. Thank you. Yeah, sir, how many seats does this restaurant can hold?
That we're going to have 8 tables.
8 tables? What, 4 seats to a table?
4 seats.
4 seats each.
Okay, we have a plot plan here, but it doesn't show us any type of parking situation. I kind of agree with the neighbors. It's a very, very tight spot here. There's no parking in front on Branch Street, and Dover Street is, it's kind of a tough area for the neighbors. Let's hear what the board members have to say, but like I said, it's going to be pretty tough. Go ahead, Corey.
Through you, Mr. Chairman, I happen to agree with the chairman on his decision. The city recently spent a lot of money redoing the triangle right in front of the package store. That made the street even narrower. I mean, this location has absolutely no off-street parking as it is. And the neighbor hit the nail on the head when she says that traffic will flood into the streets and right in front of her house more often than not, I'm sure. I'm all for Mr. T's business venture. I think there's many other empty locations in the city he can pursue. I don't think this is the spot, Mr. Chairman, in all honesty. Thank you very much.
Thank you, Corey. Go ahead, Jack.
I agree with my fellow board member, and maintaining consistency is one of the things I think that the board takes pride in, and we've had similar petitions over the last several months in which parking was identified as a major need, and we denied the petitions. I think in all fairness to those petitioners who came in with similar petitions in areas that were highly congested, we denied the petition, and I think in order to maintain the consistency and also address the quality of life for the neighbors, I think we need to deny the petition. Thank you.
Okay. Go ahead, Dan.
Thank you. Mr. T, is the spots that you show on the map, the 10 spots that are existing, whose spots are those now? Are those for everybody in that building, or?
The 10 spots that we have shown you, sir, that belong to the building that we intend to open the restaurant. It's our parking lot.
So that parking lot is exclusively for your use? Is that coming with the lease?
Yes, it belongs to the restaurant property.
Be part of the lease. I think you're right as far as it being congested in that area. However, we have approved things in that area that have made work. I'm not sure if 10 spots is enough when you're seating 32 people. And I'm not sure if there's a way to get more spaces out of that property or somewhere else in that neighborhood. But 10 spaces just isn't going to be enough because you're going to have some employees. We need to park them somewhere also. Plus, you're not showing handicap spots, and I just think it's a little too much for the property right now. That's all I have right at the moment, Mr. Chairman.
Okay, I'm actually looking at the plot plan. Donna, did you want to say something? Go ahead, Donna.
What are the hours of operation of the laundromat?
Pardon?
The hours of operation?
From about 8 a.m. to 7 p.m.
And every day? Is that 7 days?
Yes, ma'am.
And what would the restaurant hours be? Is that the restaurant hours?
That are business hours.
Business hours. For the laundromat also?
The laundry is closed, and we try to make it as a restaurant instead of laundry and restaurant, just only restaurant. So I just want to move my business from the current restaurant to the new location, which stated on 278 Pine Street.
And how many employees would you have?
That's all family business, about 3 to 4 people.
And where is your current business?
The current business is located at 264 Branch Street.
Thank you.
Jack, you want to say something?
Through you, Mr. Chairman, I have a problem with the parking. I just don't think that there is enough parking for that business to go in there, so I would not be in favor of this petition. Thank you.
Okay, I'm looking at two different plot plans here. One shows Davis Way, and it's a pretty good plot plan, but it doesn't show the parking on this plot plan. Then you have another one done by the architect, and he has some type of parking there. The architect, on the plot plan that he did, it's no way it's gonna work. Do you own a Davis Way? Is that a piece of property that you own? Or is that a private street or a paper street?
David Street
យ៉ាយើងអូន
កន្លែងណា
ក្នុង parking lot
I own the property that located at the corner of Davis Street and Brand Street, that particular corner.
Okay, Davis, do you own Davis Street? It says over here on this plot plan, Davis Way. Is that,
Like Davis Square.
Davis Square នៅឲ្យទៅមកខាងស្រាអានោះក៏រត់
No, Davis Square is belong to the city. That
belongs to the city?
Yeah, that public parking area.
Well, the sketch that the architect drew doesn't match up with the surveyor, and that's why the surveyor probably didn't put this on the plan, because there's no way it's gonna work. I mean, you got where he's got parking up front close to Branch Street, you've got 15 feet, which you need at least 20 feet, 18 to 20 feet for a parking spot. You probably have 2 or 3 of those spots that won't even work. I mean, yeah, we have 10 on a plan that an architect drew, but probably about 3 or 4 of those aren't gonna work. That's why the surveyor didn't put them down. So realistically, you probably have about 6 parking spots for a restaurant that's gonna seat 32 people. And there's no parking on Branch Street whatsoever. And now what you're gonna try to do is park on Dover Street, which you might be able to get in the front, maybe 2 or 3 cars, if you're lucky. And then what you're gonna be doing, you're gonna be encroaching on these neighbors further up on Dover Street and parking in front of their homes. So I don't think it's fair to them, and I think it's just a very tight spot, and I honestly don't think it's gonna work. We'd be more than happy to help you on something else, but this particular spot, well, like I said, for 32 seats, 6 parking spaces, just not gonna work.
May I say something in
Yes,
response?
go ahead, most certainly, go ahead.
My current business right now, that we don't have any designated parking in front of the restaurant, and we use the public parking along the street, Brand Street, and also the street at the public parking as well. So the customer use all of that, and right now we have the new established business, which also have the land that's suitable for 10 cars, and also plus on the side we have the 2 open space that draw the line, and also the corner in front of the restaurant. Dover Street that can also accessible for 2 extra cars.
Okay. In front of Branch Street, you're not gonna be able to park anything in front of Branch Street. That street's so tight. There's no parking space allowed there to begin with. Dover Street, you probably have about 55 feet of frontage. You might be able to fit 2 cars, if you're lucky, maybe 3. And then, and after that, you're gonna be encroaching on the neighbors, in front of the neighbor's house.
Yes, that we use quite often for the people or the customer who prefer to do the takeout rather than sit it in. And we have very low percent in a sit-in customer rather than the take-out customer.
No, that's fine, but let's say if you get a busy day and you get 32 seats that are full, and then you get the people that are coming in to take out on top of that. Now, where's everybody gonna park? I mean, if he's got a restaurant for 32 seats, he wants to fill the restaurant.
Well, Mr. Chairman, that I see that it's not a newly established restaurant. We just move from the current location to the next one so that we can serve the customer better and meet their needs. And I believe that right now we don't have any designated parking lot for the current business either. And with a new location, we have the paint line parking for the automobiles in our dwelling as well.
Well, what you have right now is just not enough parking, that I feel. And I think the rest of the board members feel the same way, to take care of your needs in the restaurant. If you want to, if the board feels that this goes either way, later on, if you want to find another parking location to solve your problem here, we're more than happy to work with you any way we possibly can.
I have a question.
Through you, Mr. Chairman.
Go ahead, Jack.
The other point which my fellow board member, Mr. Belanger, and I were discussing, that Davis Way, right adjacent where the plot plan indicates edge of pavement, there's a large multi-family right there as well on that side of Davis Way.
Okay, thank you. Good then.
Mr. T, what's the reasoning for moving?
ព្រោះខ្ញុំនៅតែ2ឆ្នាំនេះទៀតទេដូចទៅដល់ទីហ្នឹងព្រោះថ្ងៃគឺអត់ចំណេញទេខាត់រកខែទេទៅបិទចោល2 3ខែទេទៅកន្លែងទូនអត់មានកន្លែងចតឡានសោះហើយមកខ្ញុំចង់ឲ្យរំខានដល់គេផ្ទះចិត្តខាងហើយ customer ចតតាមផ្លូវខែ snow នេះព្រោះយើងមានដីយើង parking វា8កន្លប់អីណាចង់ដីយើងមកស្រួលអត់មានដូច្នេះលេខសល់2ឆ្នាំទៀតបានដែរបាទ2ឆ្នាំទៀតបានដល់ខ្ញុំចង់ធ្វើមុន
So this is a part of business planning that I want to look ahead in the future. Our current leasing for the restaurant, I have about 2 years to go from the current leasing. So when I look at my business at the laundry, I don't make much money right now. The businesses seem to kind of slow down. So I thought that when I got that building, that I can just move after experiencing with the small business and also the traffic itself that don't have any allocated or designated parking. I thought that the laundromat dwelling may be replaced by the restaurant business instead, and also that in that new property, I also have the land available for parking and to serve the customer who use my business.
Well, the reason why I asked that is he has an ongoing business now, and maybe he can take some time to relook at this plot plan and see if he can do a better job on getting some more parking and bring it back to the board with some serious changes, I think you can bring it back in for another review. And again, if you have another 2 years to go, maybe this will give you some time to procure that type of information. It's, because I agree with the chairman, it's going to impact the neighborhood a great deal. And I think your restaurant already is impacting the neighborhood. So you have an ongoing business. You should probably stick with that right at the moment and see if you can improve the next location so the neighbors would even be more pleased with you. You'd be improving it for them also. It's just that this one here is not going to work. You just don't have enough spaces.
I need a motion.
Make a motion to approve?
Are you all set, sir?
And also just want to let you know that the my laundromat also closed for the last 3 months already.
Okay, thank you. We need a motion, please.
Make a motion to approve?
Any second?
Second the motion.
Call the roll.
Mr. Squalia?
Deny. Ms. McMahon?
Deny. Mr. Flynn?
Deny.
Mr. Belanja?
Deny?
Mr. Kazanjian?
Denied. And Donna, can you just put a note that it's been denied for a parking reason?
Parking, sure.
Okay, it'll help out Kim. Thank you. You've been denied with 5 votes. If you have any questions, you can come up to the,
ខ្ញុំនិយាយខ្មែរទៅគេថាខ្ញុំសុំមកលើកក្រោយទៅថ្ងៃណាខ្ញុំ
okay, this petition, this petition he brought forward tonight was denied by the board. We'll be more than happy to work with you. The reason why we did deny it was parking. We feel that you don't have enough parking for the business that you want to start up, and we feel it's going to be impacting the neighborhood considerably. So that's the reason why they denied it. Excuse me. If you have any questions, or if you want have another some additional parking close by, we'll be more than happy to work with you. Or if you have another location.
He have one question.
Yes, go ahead.
He accept the board decision about denial of his request to open a new restaurant. However, that he just want to know that whether if he would be able to come back to the board again for a review of his request when
He would have to, he'd have to go through the whole process again.
Okay, thank you.
Okay, and if you have any questions, just go to the building department, and they'll be more than happy to answer your questions. Okay? Thank you for coming. City of Lowell, 251 Mount Vernon Street, to reaffirm special permit variance previously granted December 2003, but not exercised, to substitute the non-conforming use and storage warehouse to studios and musicians without the required parking in former M4 zoning district.
Mr. Chairman and members, for the record, my name is Ann Barton. I'm the Deputy Director at the Division of Planning and Development for the City of Lowell. Here again before you tonight to ask for an affirmation or reconsideration of a relief previously granted, special permit and a variance from parking. If you recall, this is a building located on the new Stocklosa School site that the city wished to maintain because of its historic significance. It's a stone building. And we are asking that, and reached a settlement with, and are asking that a former owner of property on that site be allowed to locate here. The city committed to work with him through the permitting process, and in developing architectural plans that met with our approval under review of the Historic Board and DPD. We have been doing so. It has been a lengthy process because of the historical nature of the building, finding appropriate windows and treatment for the exterior and some structural inspections that needed to be done. I feel we have reached a point now that we are ready to move forward with this party, and we would ask that you consider extending or reconsidering this relief so that we can do so and meet the obligations of our settlement agreement.
Okay, thank you, ma'am. Is there anybody here like to speak in favor for this petition, in favor? Anybody in opposition? In opposition? Okay, hearing none, let's open it to the board. Go ahead, Corey.
Through you, Mr. Chairman, I can understand the delays with a building of this historic significance. It's a beautiful building, and I think we owe it to the artist community and the city to move this forward, Mr. Chairman. I'm all for it. Thank you.
Okay. Go ahead, Jack.
Through you, Mr. Chairman, I guess I would just have one question. It says that the use, it says studios for musicians. Does that mean it's rehearsal space?
Yes, it is.
And so acoustically, all of those properties have been addressed, so it's going to be soundproof and all that kind of stuff?
Yes, that's one of the complex issues moving forward. It is a special construction that does provide soundproofing.
Terrific. Thank you very much. I agree with my fellow board member that the historic significance, as long as those have been addressed for the neighbors, and I also would be in favor of it. Thank you.
We can make that a condition if you want, Jack, if you're going to be happy.
Excuse me?
We can make that a condition, make sure it's going to be soundproof.
Thank you.
That's your intent?
Yeah.
Okay,
that'd be
good.
fine.
Good, Dan.
Thanks, Mr. Chairman. Now that there's a school there, school department, everybody's been involved, and they all know what's going there?
I have met with the principal of that particular school, or the acting principal, and we did discuss this issue. I'm not sure if they're aware of tonight's action in this whole process. They are aware that the building is under the city's control to be used once again.
The city's going to remain owning it, or you're selling it to this gentleman?
The agreement calls for the city transferring ownership of the property to the parties, the Turcos, the former owners of 231 Mount Vernon, upon completion of the fit-out.
And that property is possibly going to be across from the final acre that we've been hearing about, that residential neighborhood?
It would be, and we have considered that, and we have talked extensively with the parties about that before deciding to use this building. But because of the soundproofing that they provide and the nature of their activities being off-school hours and such, we felt that could work. They currently are occupying on a temporary basis space on Rock Street, and in talking with neighbors in that area, they have not heard, and it has not been a nuisance there thus far, so.
When you say off hours, any idea what their hours are?
Generally, I believe the bands practice anywhere from after work hours, 5 o'clock on. They could go into the early hours of 1 or 2. And then on weekends, typically, there's loading and unloading as they go out to performances and that sort of thing.
I know we approved it, and Mr. Chairman, I really don't have issue with it. It's just that a lot has been developed over there, and more will be developed on Mount Vernon, as you know. I'm not sure if this is the type of thing that you can put a yearly review on, or a 2-year review, or something. I just hate to see something be forever and see a lot of new development going in there, and maybe what might work now won't work 5 years from now. That's all I'm saying. So.
Yeah, Jack.
Through you, Mr. Chairman, I agree with my fellow colleagues. I think it would be no problem with this petition. Thank you.
Okay. Donna, you all set? I agree with Dan. I think right now, there's no problem there. Everything's pretty much industrial or business zone. But if Susie ever does something with his property, and they put some houses there, what's going to happen down the road? To fit this out for the owner of the Turcos, I should say, what do you figure? It's about 6 months before they move in?
I would say, estimate that it's about a 6, maybe 8-month fit-out.
Okay. Why don't we, I don't think anybody has a problem with it. Maybe we can do something with a if it does get approved with a condition that it gets approved with a yearly review from the board, and if it does get loud and obnoxious for the people that do plan to move in there, because your intent is to put some houses across the street, is that correct?
That's correct.
Yeah. I don't have a problem doing that. And make sure it does have some type of soundproofing.
Okay, Mr. Chairman, I concur, and I would like to make a motion that we do approve this petition with the following conditions. The first condition is it will come back for a yearly review before this board, and the second condition is if there's a question about soundproofing, it has to meet a standard that the building department knows by code, and those are the two conditions I would have.
I need a second.
Second the motion?
Call the roll, please.
Ms. McMahon?
Approve with conditions? Mr. Flynn?
Approve with conditions.
Mr. Knox?
Approve with conditions.
Mr. Kazanjian?
Approve with conditions.
And Mr. Squalia?
Approve with conditions.
And we need to sign some paperwork before you leave. Okay, thank you. David Kosh, Attorney Kevin M. Carroll, 256, 260, 284, 300, 300 Lawrence Street. Appeal of the building inspector's decision to deny demand for cease and desist order of the ongoing townhouse construction and revoke building permit for the same. Yes, sir.
Good evening, Mr. Chairman. I am Attorney Bruce A. Gage of the Saab Law Firm here in Lowell. I'm appearing for Kevin M. Carroll tonight. We represent Mr. David Koch of 18 Mill Street, who is the aggrieved citizen of Lowell due to the inaction of the building inspector in this case. Mr. Carroll gives his apologies, but Mr. Koch won't be appearing here tonight or testifying due to advice of counsel. We have a pending matter at Lowell Superior Court on a MGL 40A Section 17 related matter, so he won't be testifying here tonight. I'm here tonight to appeal a decision of the building inspector regarding a cease and desist order that was requested by Mr. Koch on June 8th, 2006. This was denied by a letter from the building inspector on June 20th, 2006, who stated that the setback provisions and the wetland provisions that we had cited in the letter were inapplicable, and he went ahead and issued the permit. The reasons he listed about 7 reasons for denying our permit. I'd like to go through them one at a time.
Go ahead.
Counsel, if I may interrupt, I want to make a tape change, so
Okay.
it's recorded. Thank you. Continue.
His first reason was the issuance of a permit is a matter of duty and not of discretion, and therefore he didn't have a choice but to issue a permit in this matter. We agree partially with that statement, but we would state that the issuance of a permit or the non-issuance of a permit is a matter of duty. And in this case, we think that Mass Reg 780 CMR 111.2 is quite informative, because it states that no permit should issue if the construction of any building is in violation of any zoning ordinance. The second reason he gave for disallowing our request was he cited the exception to the Lowell zoning ordinance, 5.2.6. And it's the exception that allowed him to average the setbacks on adjacent lots. Clearly, that's not the case in this matter. They are going to raise the buildings on these lots, take them down. So if you go further in the same statute, it says clearly that in a vacant lot, a 15-foot setback is required, which was totally ignored. The third thing he used to deny our relief under Chapter 40A, Section 7, was that this was not in a wetland area. I have brought a couple maps. Mr. Chairman, can I
Please,
come
yes,
forward?
bring them up.
Because I think they're instructive on this matter.
That's fine.
Mr.
Okay,
Chairman,
go
if you look at map C, designated C1 in the right-hand corner, you will see that in the upper left-hand corner it says wetland flag, and then in the highlighted portion are the wetland flags have been highlighted throughout the site plan at 260 Lawrence Street. On C2, which is the other map, it then highlights the 50-foot, in the pink highlight, the 50-foot buffer zone for that wetland designated area. And as you can see clearly, it goes across the almost 7 condominiums that he wants to build there. Clearly. The provisions of 5.2.3 of the Lowell zoning ordinance are clear that in order to construct within 50 feet of an existing wetland, a special permit would be required with written approval of the Conservation Commission. This was not done in this case. The building inspector also alleged that our application was untimely in this matter. He said that David Koch had received notice of the intention of granting a permit through his attorney, one Louis M. Saab, on February 11th, 2004. But clearly the case law is informative on this as well. If Vokes versus Lowell, 18 Mass Appeals Court, 471, is a 20-year-old case that's still the case cited through all the books. And it states clearly that the date in which a zoning enforcement officer responds in writing, which was what Mr. St. Hilaire did on June 20th of 2006, to a Section 7 request, which was our letter of June 8th, 2006, creates the appealable decision contemplated by Section 8 and becomes the date for measuring the 30-day appeal period. Moreover, this case is more informative because it states clearly that there's a 6-year statute of limitations for those aggrieved by the issuance of a building permit, which is what happened in this case. We're well within the statute of limitations. Moreover, in Balcom versus Town of Hingham, affirmed the fact that the statutory requirement is mandatory for written notice and communication between the building inspector and any such third party, such as Mr. Koch. Again, there was no written communications until June 8th, 2006. The fact that Mr. Koch had visual notice that was mentioned in the letter, or the fact that he received a phone call from Mr. Koch in April 2003 are irrelevant. The statute is clear. The cases are clear. It's the written letter, June 8th, that controls. And that was followed through the statute, and our appeal is timely. The last thing the building inspector alleged in his letter was that Mr. Koch is not an aggrieved party. Again, this is not a correct reading of the case law and the statutes. The building inspector has the burden under the statute because Mr. Koch has a presumption as an aggrieved party living within 300 feet of this area. The Mass Appeals Court has held he's presumed to be aggrieved under the statute in Bedford versus Trustees of BU. Moreover, under Section 8, Mr. Koch is an aggrieved person for his inability to obtain enforcement of the zoning code from the building inspector. And again, that's in Volks versus Lovell. In concluding, we'd like to state that the building inspector has a legal duty to deny permits when they don't follow the zoning ordinances. In this case, there's definitely, we were within a wetland. He didn't follow 5.2.3 as far as the setback provision. And the notice provisions are absolutely inadequate. We filed under Section 7 our letter on June 8th as required. We had 6 years to file that. We did it within 2. So our appeal is timely, and he's wrong as that. And Mr. Koch is an aggrieved person under the statute. Thank you.
Thank you. Is there anybody here like to speak in favor? In favor? Mr. St. Clair?
May I approach the chairman for a minute?
Absolutely.
I'm here tonight to answer why we're not going to revoke Mr. Darling's permit based on the June 8th letter, 2006. The Zoning Board of Appeals has the right to hear any aggrieved party of the decision of the building inspector within 30 days under Chapter 40A, Section 15, which I just handed to you. The building permit that they would like revoked was issued October 15th, 2004. The appeal deadline would have been 30 days later, November 15th, 2004. June 8th, 2006, I was asked to revoke that permit. The appeal process has long passed. To appeal the building inspector's decision has long passed. Mr. Saab, Mr. Carroll, and Mr. Coach were all aware permits were going to be issued. Mr. Saab contacted my office the very next morning after the Board of Appeals hearing, wanting to know the report number. We didn't have it yet. He called 9:15, and I requested why he wanted it. He said he was going to appeal the decision of the Board of Appeals, and I informed him at that time that the requests and the variances that Mr. Darling was looking for was not needed, and a permit would have been issued. Mr. Saab, or Mr. Carroll, who works for Mr. Saab, should have appealed that decision within 30 days. Shortly thereafter, we did issue the permit. Now the decision is in writing. They had 30 days to appeal. They failed to do so. The Board of Appeals, well, I referred this gentleman's letter also to the law office. The Board of Appeals has reviewed this. And it's my belief, and it's our law office belief, that the Board of Appeals does not have jurisdiction at this time, and would like to request that the Board of Appeals rule that they do not have Board of decision at this time to make a decision based on Chapter 48, Section 15, the appeals process, because it was not done in a timely fashion. Mr. Coach and Mr. Carroll do have other options. There is court proceedings that they can go through. That's where this belongs. It does not belong here before the Board of Appeals, and I cannot revoke a permit upon their request after that 30-day period.
Okay, thank you, Mr. St. Clair. Yes, sir.
Mr. Chairman, may I be heard? I have a copy of Vokes versus Lowell, and I'd like to bring that forward now.
Please.
It should be highlighted in yellow. I believe it's on page 7 of the holding. This is the Mass Appeals Court. This is the case cited for how this statute works. We conclude that the date on which a zoning enforcement officer responds in writing to a Section 7 request for enforcement, which was, we requested the Section 7 relief June 8th, 2006. And he responded on June 20th, 2006, creates the appealable decision contemplated by Section 8 and becomes the date for measuring the 30-day appeal period. It has nothing to do with oral notice. It has nothing to do with visual notice. This is clear. This is the law. We will win if we go forward. It doesn't make sense, but we will win as a matter of law. This is the statute, and this is how it's interpreted by the courts. Moreover, the building inspector didn't address the fact that we have a violation of the zoning ordinance as far as the wetlands provision. We have a violation as far as the setback provisions. This permit should be void ab initio, and we should go forward. Thank you very much.
Okay, thank you very much. Is anybody else like to speak in favor? In favor? Anybody in opposition? Okay. Before we do open it to the board, we do have a letter here from the Law Department stating this is the ZBA should advise Attorney Carroll that it does not believe that the ZBA has jurisdiction over this matter because it failed to appeal the insurance of the building permit within 30 days. We're not attorneys here. We are advised from the Law Department that we don't have a right to a vote on this tonight. I'm going to leave it up to the board members to see how they feel, but this is just a heads up, and I think everybody got this letter also, a memo from the Law Department.
Through you, Mr. Chairman.
Yes, Jack.
Based on the advice from the solicitor's office, we've been advised that we do not have jurisdiction, and the motion should be to deny based on the fact that we do not have jurisdiction over this. And I certainly would concur with the solicitor's office.
Anybody else want to comment? Okay, I'm going to need a motion, but let's make sure we do it right.
Jim, I think it would be a vote of no action, perhaps.
Go ahead, Dan.
Mr. Chairman, I can make a motion with the guidance from the law office upstairs that we take a no-action vote on this tonight and send it back upstairs to them.
I'll second the motion, Mr. Chairman.
Okay, call the roll, please.
The vote will be to approve, to deny, and uphold the decision of the law department.
Okay. Approve.
No, it's going to be just uphold the decision of the law department. No,
Okay, uphold.
okay?
And again, I apologize, Mr. Chairman, because we're not attorneys, and I just want to try to get it right for all parties, for Mr. Koch, for the city. And what I'm trying to do here is get it back to the law department's hands, because they obviously think that's where it should be. And that was their advice to us.
Okay, and that motion, Donna, is, which,
Uphold, right. Mr. Flynn?
Uphold.
Mr. Knox? Mr. Knox?
I'm just looking for some clarification.
I think we're going to vote on just uphold the decision from the law department.
Okay.
Jack, I don't want to vote to approve or
Upholding-
deny it, because it's, could be a legal matter, so I
So
think
it's
that'll be
upholding the
best bet.
decision referring to back to the city solicitor's office, correct?
Correct, that's it.
Then I uphold.
Mr. Kazanjian?
I want to uphold the decision from the law department.
Mr. Squalia?
Uphold the decision from the law department.
Okay. It looks like we got 5 votes to uphold the decision from the law department, sir. Thank you for coming, and Mr. St. Hilaire, thank you for coming.
Mr. Chairman, I think we should wait on the minutes until the packet's updated.
Okay, I need a motion to adjourn.
Make a motion to adjourn?
Seconded.
Everybody in favor, say aye.
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 Chair votes yes.